Good afternoon. I want to welcome everyone to this afternoon's meeting of the Senate Committee on Legislative Operations and Elections. We are pleased to have presenters here in person in Carson City as well over Zoom. We are hearing four bills today: Assembly Bill 385, Assembly Bill 390, Assembly Bill 421, and Assembly Joint Resolution 1. Madam Secretary, we do have a quorum present. Please mark Majority Leader Canizaro present when she arrives. A few housekeeping announcements. As everyone knows, the legislative building is now open to the public with limited capacity and appointments that can be made for meetings with legislators and to attend committee hearings in person. For everyone in person and online, we do ask that you keep your devices muted when you're not speaking and either silence or turn off your electronic devices here in the committee room. For all individuals present here in the room, we do ask you to keep your face covering on and to maintain social distancing. Even with the legislative building open, most are still viewing committee meetings online through the legislature's streaming service or on the legislature's YouTube channel. These meetings are also recorded for viewing at a later time. As you know, committee information is available on the legislature's website on Nellis and can be accessed that way. Those wishing to provide testimony or public comment should register to participate through Nellis and select their preferred method. If you register to make your comments by phone, you will receive an email confirmation with the call-in information. You may also submit written comments as outlined on the agenda. Detailed instructions for participating are available on the help page, linked in a banner at the top of every page on Nellis. When testifying, we do ask that you state your name and please spell your name, and if you represent an organization, please let us know who you represent. We'll take public comment at the end of the meeting, and public comment may be limited due to the time constraints. You may also submit your full comments in writing and briefly summarize them in spoken testimony if you'd prefer. Finally, we do ask everyone to be courteous to others and respectful in our interactions, even if we don't agree on some of these contentious issues. I know that was a lot of housekeeping information, but please don't hesitate to contact my office or committee staff if you have any questions or need help. Before we begin the hearing, I wanted to just announce that we are going to change the order of our agenda. We had a request to have Assembly Bill 390 heard last on the agenda. So if you're here to speak in person or on Zoom for Assembly Bill 390, it will be a short while before we begin the hearing on that bill. Before we open the hearing on Assembly Bill 385, we do have one committee BDR that needs introduction by the committee. Today we received from the Legal Division BDR R-1148. It's a measure proposing the creation of a joint special committee to conduct a study concerning innovation zones. I want to remind all members that a vote to introduce this bill draft request is in no way an indication or a commitment of support. The committee's approval is needed, however, to get this resolution in process, assigned a bill number, and a referral to a committee so that it can have a hearing. I would accept a motion now for introduction on BDR R-1148.
Senator Lang, for the record, I move that we introduce BDR R-1148.
Thank you. I have a motion from Vice Chair Lang. Do I have a second?
Second.
I have a second from Senator Sievers-Gansert. Is there any discussion on the motion? Okay. All those in favor, please say aye. Aye. Any opposed? Thank you. The motion carries. Secretary, please note that passed unanimously, and Majority Leader Canizaro was excused. And copies were handed out. I should have mentioned that before of the bill draft request to all members. Now we will open the hearing on Assembly Bill 385. Thank you, Assemblywoman Benitez Thompson, for your patience. Welcome to the committee, and we appreciate your being here and your patience.
Good afternoon. Thank you so much, Senator Orenshaw and members of the Senate Legislative Operations Committee for hearing Assembly Bill 385 today. It's my pleasure to bring forth this bill. Hopefully I can make my best case for why this is good public policy and convince you all that we're doing good things with it. So we're going to be talking about the contracting of public employees' positions. So most of the employment positions within public agencies are classified jobs with defined steps and grades and benefits. They are transparent and for the most part predictable. In public agencies, contracted employment positions are typically the top two tiers of leadership within the organization. They are demanding jobs where leadership often has to serve as the outward face of the organization and interact frequently with public boards and and electeds. And let's not kid ourselves, dealing with electeds on a daily basis can be arduous. These are arduous, demanding jobs. The high salaries of these jobs reflect the sophisticated skill set of these individuals. On the whole, public bodies and local governments contract routine salaries and benefits. On the whole, 99.9% of our public boards and public bodies are engaging in good, transparent processes. However, over the past 5 years, I've observed a trend among certain public bodies to create outrageously generous benefits and bonuses into these contracts. I've written AB 385 to end such practices and prevent future public bodies from perpetuating these trends. I believe 385 protects public tax dollars from being encumbered as golden parachutes by a handful of highly salaried individuals. I believe it will ensure transparency and good public stewardship of public dollars. And although I don't wish to do so for every piece of the bill that I've written, I have specific instances of where we have seen public bodies negotiate things into contracts that played out badly in the end. I'll go to the bill now, Assembly Bill 385. Section 1 is the bulk of this bill, and I will walk you through Section 1. So the first part of Section 1, 1.1, is the shall nots. And so, except as otherwise provided in this section, a public body, and as we define public body, we're making the reference to NRS 241.015. So this is meetings of state and local agencies. So essentially, you know you're in this bill. You know you are subject to this bill if you have to follow the open meeting law. Shall not enter into employment contracts that entitles an employee or public officer to receive fringe benefit unless the body has adopted a policy authorizing all persons in that similar position to receive the fringe benefit. So the goal of this is to prevent the outliers. The goal of this is to prevent a public body from approving requests that they wouldn't ordinarily do. And we have seen a couple specific examples where you can see people asking for things that in those leadership positions that other folks don't have within the body of that organization. B would be bonuses, unless the bonus is based on merit and awarded at a public meeting. So ideally, bonuses are always tied to merit. Bonuses are always tied to performance, and bonuses are always discussed in a public way so that the public body says, hey, here's how we're going to evaluate you and evaluate your performance, and that employee has the ability to demonstrate that they are indeed meeting all of those standards and metrics. But we have seen, even as recently as this past January, boards award bonuses right into contracts, bonuses, guaranteed amounts, guaranteed percentages of people's salary without any other strings attached. And in this last example, that would be a guaranteed bonus of $101,000 annually with no strings attached. The other would be, and this is very important, the third shall not, the C, is that upon the termination of the employment of the officer or employee for cause or the resignation of the officer when an investigation relating to their employment is pending, they can't be paid out anything like additional severances and bonuses that they might have. And the goal here is to say that if there's questions about a person's conduct, and if there's an investigation going on, if there's fact-finding going on, then the public body deserves to know the outcome and the results of that process before they are obligated to have to give out additional bonuses or additional pay beyond the last day that's worked. So a good example would be, let's say that you are the head of a quasi-governmental agency, right? And that there's questions about the culture of the agency, and they do a survey of employees to see how things are at the ground level. And let's say that survey comes back with a lot of concerns, and from those concerns, a formal sexual harassment allegation process is started. Well, if someone resigns during the course of that investigation, then that public body would have to still give them that bonus, right? That $100,000 plus bonus, Still, any other severance that they negotiated in their contract at the beginning of their employment, so if they negotiated a 6-month severance, then that they would have to pay all of that without knowing the outcome of that fact-finding or investigation process. For public bodies, what that means is that oftentimes once that investigation is done and those findings become public, you can end up in a spot where you are less than proud, perhaps, of your previous decision because you didn't have that information in your head. You were contractually obligated to give those additional pay and bonuses, and you didn't have any type of way to prevent the organization from having to pay out those taxpayer dollars. 2 would be that is to clearly say what the public bodies will. So now we're going to talk about what they ought to do so that they're not confused with the shall nots. We just wanted to draw a bright line here. Upon the termination of the employment of an officer or employee, the public body must pay to the person, be paid for any portion of accumulated annual leave or comp time or sick time. So want to make it really clear that we're not talking about anything that the employee has earned, or anything that they've earned through the course of work, anything that they've banked during the course of work. That is not counted as a severance pay. B, that the employee remains entitled to any pension or retired benefit through their public employee retirement system. And so we're not touching your pension. That's not on the line here. Public body can't decide that for these leadership positions that go wrong, that they're going to withhold their PERS unless it's otherwise covered somewhere else in another chapter. Or receiving compensation for past services upon their termination. Also, that the employee can still bring a cause of action for wrongful or unlawful acts relating to their termination. Also clarifying here that if the public body can enter into agreement to pay the cost of purchase credit for service on behalf of the officer, because we have seen that happen a couple of times, and it's typically in line with practices that the public body is otherwise doing, but we just wanted to make sure that we put a bright line on those couple of things. Want to make sure as well that we talk about who this does not apply to, so that we can clearly define that we're talking about these contracts that tend to be in the higher up leadership positions, that they do not mean contracts negotiated pursuant to a collective bargaining agreement. So those, once again, are, falling outside of this bill, not applying to NSHE as well. And so we've done a lot of work on this bill to really try to make sure that we are taking a surgical approach to some bad practices that we've been seeing. And really, this is the time to pass a bill like this. And the reason why is because it's just an emerging trend. It means we have the opportunity to nip it in the bud. It means that in a decade from now, legislators don't have to bring back a bill where a lot of these types of requests in contracts have become common practice, and we don't have to argue about whether or not we're having a taking from someone because it's just become so prevalent and there's a precedent for it. Some examples, very generally, some examples of practices that I am trying to get at, and want to put these on the record for the clear point of understanding the fact that most of our public bodies are doing an amazing job, and that it's really just a trend in certain areas that we see emerging, and just to giving these examples to highlight for the record and the legislative record the example of what I would consider as a sponsor of the bill, some of these outliers that we are trying to nip in the bud. So regarding resignations, so in this scenario, the CEO who resigned received 3 months medical pay from the board as well as 3 months severance pay. The CEO resigned well under internal investigation and was later to have found violated at least 13 policies and procedures, including those dealing with harassment, violence, retaliation, and discrimination. That same CEO was also awarded over a $100,000 bonus shortly after the investigation was concluded. So if the public body had known that information, if that public body had been able to say, wait a minute, we know more about what's happening, then contractually, they might not, with this bill, have to been obligated to kind of give someone a golden parachute as they were resigning and walking out the door. On bonuses, this past January, CEO received in his contract a bonus of 35% of his pay, or $101,000 annually, with no goals, with quote, no goals or guidelines in place on what this person would have to do to earn that bonus. And just really think that hopefully that's when we can all agree that bonuses should be based on something and should not be contractually written in as an automatic annual payment. On fringe benefit, and I've had lots of conversations with local governments because they're worried about fringe, and I tell them, I think that you're okay. Most of these are ripped from the headlines. Most of these get picked up in a way that are sensationalized, so most of them are doing very good. But to put some good examples on, we'll talk about car allowances. So it can be very typical for all employees, for a public body to have a policy regarding mileage reimbursement or the use of a motor pool car. Those are kind of the two practices we see that are out there. And in some of these leadership positions, what they're negotiating is an additional $800 or $900 a month car allowance payment, in addition to the access to the motor pool and a mileage reimbursement. And so with Section 1.1, where we talk about the organization having a policy, if the policy for everyone is mileage reimbursement or motor pool, then the public body could not walk down the path of talking about additional types of car allowances. They would just have to stick with what the policy of the organization is. Excessive fringe, another good example would be asking to have in your contract, let's say $5,000 health and wellness allowance. It's above and beyond your health insurance policy and what your health insurance policy covers. So once again, getting to that reference on excessive fringe, if the public body has a policy stating that, here's our health care benefit policies, and if they could even have a policy that says we encourage health and wellness, and so, we've negotiated for our employees a discount to a gym. Great. That's something that it would be considered ordinary within the practice of that organization. But if there's one person who's asking through their contracted employment to have an additional $5,000 benefit, then that one person with that one benefit that they ask for on the front end. So it's just to put some guardrails on what public boards can say yes and no to, especially everyone has the best of hopes and intentions when someone is newly hired. When, the boards have a strong belief in their new leadership, and we want to support that belief, but we also want to make sure that we're continually enforcing good stewardship of taxpayer dollars, transparency in the process, and more than anything, public faith in what we are doing when we make these kinds of decisions. And I'll stand open to questions.
Thank you very much, Majority Leader Benitez Thompson. Thank you for presenting the bill. Members, any questions on Assembly Bill 385? Senator Sievers-Ganser.
Thank you, Chair Orenshaw. So number 1.1, I guess it would be A, the similar position. You'd said the top two tiers. It seems like usually when I see these contracts, and they are pretty common, I see the head of an organization. It could be the head of the city manager, county manager, the RCBA, the RTCs, all those types of places. And so when you say similar position, you had mentioned two tiers, and I'm not sure.
Thank you so much for the question.
I don't want it to encourage them to offer it to multiple tiers.
I appreciate that. I appreciate that so much. To Senator Gansert from Assemblywoman Teresa Benitez Thompson through
Thank you.
Chair
Please go straight to
Orenshaw.
the senator. You don't have to go through the chair.
That's so kind of you, Chair Orenshaw. To Senator Gansert, Teresa Benitez Thompson for the record. So the school districts let me know that sometimes in certain districts, their assistant superintendents are also those specialty contracted positions where they fall outside of collective bargaining, and they don't necessarily have a peer group just because the size is so small. So in those instances, you would have, your superintendent and then your assistant superintendent in some counties where both of those positions are contracted. In bigger organizations, like bigger counties, that second level of management does tend to be kind of more of a group that has similar contracts or negotiated contracts, even though they're outside of collective bargaining, those tend to kind of, I would say, they don't tend to be one-offs as you would think of them in that one leadership position where they are clearly the only person who's negotiating that contract.
A follow-up, Senator
Yeah, thank you.
Sievers-Ganser.
And so I guess my concern is if they want to provide that type of benefit to whoever's at the top, they can't do it unless they provide it to the 2 or 3 people below them. And so potentially could encourage them to go further instead of reducing it, that they may add more people to, say it's a car allowance. And I know sometimes what you see is a significant salary, and there's a car allowance, and then there's a housing allowance, and there's a fitness allowance, and it does go on, and I do agree with you around the transparency issue.
I appreciate that. To Senator Ganser, Teresa Benitez Thompson, for the record, did discuss the theory that this could drive public bodies to expand the pool, so kind of expand the bad practices to insulate the one. I don't think that will happen. I think it's much more likely that what you will see happen is I don't think that they would spread it out, just because I believe that would become kind of obvious and glaring, right? If the public is angered by one person getting a car allowance, they sure as heck would probably be angered by 5 or 6 people getting it. I think it will go the other way because most agencies do have such policies. So it makes sense that they would just fall into the ordinary course of their practice and remove the outlier versus moving everyone to the outliers. But I'll watch this, and if it goes that direction, I'll be the first person to correct it.
Thank you. And I had another question.
Go ahead.
A couple more questions. So if upon the termination of employment of an officer for cause or for resignation, then you're not supposed to pay wages or administrative leave. And the thing is, investigations can take a long time. So I understand, and so I'm under 1C in section 1. It's kind of confusing, so I guess it's 1C1. If it was a 6-month investigation and maybe someone didn't do anything wrong, if they're not paid for 6 months, that's how I read that. So you're going to withhold wages as long as the investigation is still underway.
The goal here, once again, is really about making sure that the public body has information before they make a decision, because once that money's out the door, you're not going to get it back, right? So the idea was, how do we create a pause? And so if an investigation comes back and it's unwarranted and it's a really clean report, then the public body is free to say, okay, here is everything that you're owed, we've got it for you. But if it came back where the public body needed to make different decisions, then they could. So for this one in particular, these were the considerations that we had for where you would see a public body want to take a pause on what could be negotiated in at the front end. So it would be while they are negotiating the contract at the front end, someone couldn't necessarily say, I am going to be paid no matter what under these circumstances. I'm going to get a bonus no matter what. I'm going to get other forms of payment, because I'm going to decide to call it anything else, but it's that compensation. And then wages in lieu of notice or administrative leave went in there as well. They couldn't by default write that out of a possibility for the public board at the onset of their contract.
Yeah, I'm just not quite sure how that's going to work, because it's upon termination. So someone's been fired, but then you're withholding wages until there's an investigation. And I'm not, maybe it depends upon how much has been accrued. And I understand, I think what you're trying to get to is sometimes a deal is cut with a bad actor and they're out the door because they just want to move on, but they don't necessarily have all the facts and they haven't concluded the investigation. But on the flip side of that, if somebody was found not to have been a bad actor, they will have been strung out potentially for months without being paid. So I'm not quite sure how to solve that. And then the last one is just other form of payment is really broad. So bonus or other form of payment, I'm not sure what that would be. But I do, I appreciate the intent, which is really, I think, this is in the contracting phase. So the contracts that are already out there, there's really nothing you can do because those contracts exist. So this is trying to set framework for new contracts. And so I appreciate the intent. I'm just not quite sure how all of it would actually work. And then maybe you would have employees or folks who would not consider going to a municipality or to a body because of some of the terms, because we're really restricting sort of the terms of the agreement. So I have to think about it some more. Thank you.
Thank you so much to Senator Gansert, Assemblywoman Benitez-Thompson. So I do not believe that this will restrict us hiring good people, because I think one of the things I see is the pay for these positions is very high. These are very, very good paying jobs. They are $250,000 plus jobs, right? And they can still negotiate bonuses as long as they're tied to metrics. But I'm telling you, I don't think public bodies honestly want the type of person who would insist on negotiating these. I think what we have to do is make sure that public bodies have the doors closed, which just will prevent them from having to walk down and have a conversation about some of these things that are, like I said, it's an emerging trend. So you don't see it happening very often right now. But in at least one article where they did a $900 a month car allowance, the justification for that car allowance was that it had been previously awarded in another contract in, I think it was 1998, so 17 years prior. So they used that precedent from 17 years ago to say, we're going to put this in, and now it's just kind of become commonplace. So it's really about trying to nip that trend. The other thing that I could pull and submit for the exhibit would be board minutes from one of these boards where they hired a search company, and you saw the board members playing out having a conversation. When the search company was brought in, they recommended going out to do a search, offering the bonuses, the annual bonuses, and offering an automatic 6-month severance. And you saw the board members question that. A couple of them say, is it a good idea to kind of offer all of that up front as we're going out to do the search? Aren't those conversations we want to have later? And so the board had an interesting dialogue, and the search company ultimately said, well, you're still going to get candidates. You won't get as many candidates, but you're still going to get candidates, right? So the public bodies are still going to get candidates, but I'd rather them have 4 great people who are coming to do the public's work and have a reasonable contract, rather than having 20 who are coming here because the lure of the ad says automatic annual bonuses and guaranteed 6-month severance.
Sure, I can understand that. And I do think there's something in transparency when you are paid a certain amount and not all these silos of funds too. So, thank you.
I will say I'm happy to talk a little bit more and to make sure that the combination of, I think what you're looking at is in 1C, I think you're looking at the combination of upon the termination of the employee, not for cause, because typically the contracts for cause will disregard that, but in some of the contracts where you get the resignation, that's where you get those golden parachutes where someone realizes, uh-oh, I'm in trouble, so I'm going to bail now and take all the goodies with me, right? And so if I think you're saying upon the termination of the employee while they're under investigation, the wages in lieu of notice or administrative leave, and the wages in lieu of notice is typically, and the practice has been a 90-day, so it's a 90-day pay if they get paid if they don't get the notice. And so I think is your concern that they would get that 90-day not pay because they're not getting the notice? And we can check, because most of the times if you're under investigation, I guess we could
I'm
talk
not
about
really
what
sure.
notice
I just
means.
know that sometimes accusations are made and someone really didn't do anything. And it seems like it's probably the other way more often if allegations are made. But sometimes there are allegations that are made and then that person and their family are sort of hung out and there's like no income because they're under investigation. And maybe they resign because these are all very public positions. So just I have an instance in mind that gives me pause. But I understand that we've had many where we have bad actors. And, sometimes what I don't understand either is upfront, the vetting of individuals, that many times there's been a record of certain actions, but they were not investigated in advance, right? So then we don't get ourselves into those positions. Yeah.
Absolutely. And I think part of what you're saying is so right, Senator Ganser, because at the front, everyone has the best of intentions. Everyone is showing their best selves, and they are hoping for the best. And so they contract and negotiate in that spirit. And then if things end badly, I think where we see things happen is that the public body has realized they've committed themselves to these payouts without regard for how things might end.
Thank you, Assemblywoman. Thank you, Senator. Any additional questions, members? Senator Buck.
Thank you, Chair Orenshaw. I was just wondering in Section 1, Subsection 4, why officers, presidents, department chairs of higher education, like what if there was an instance in which there were sexual harassment allegations was found to be true in higher ed, why were they written out?
Thank you so much for the question, Assemblywoman Benitez Thompson, to Senator Buck. In the drafting of this bill initially, we did contemplate having the Nevada system of higher education in there. What I realized through the course of the research of the bill is it's just a little bit of a harder institution to write this kind of law for. So I'm not saying that it's not deserving of the consideration, but for the time that I had to get at specific things I was looking to get at, it just didn't fall into this piece of legislation. But I'd be happy to see you or someone else beg the question. But had good conversations with them about some other policies, especially around contracts, that that concept around the last day work is the last day paid, which is how the rest of us live our lives, right? And so I'm not saying there's not work to be done there. I'm just saying that within this bill, it's not addressing that.
Thank you very much. Majority Leader, thank you. Any follow-up, Senator Buck? Please go ahead.
It's a separate question, Chair Orenshaw, is that okay?
Sure, go ahead.
Okay, I've done a lot of work looking at superintendents' contracts across the United States and so what I see is that really this bill does nothing that can't be circumvented. So instead of a $3,000 Peloton, say, they can easily write in $5,000. So how is that going to impact? I mean, I know that's one of the articles.
Well, thank you so much for the question to Senator Buck from Assemblywoman Teresa Benitez Thompson. I will say this, that I've had enough concern expressed to me from local government that I think we've got the language just about as good as you can get, right? Because we're clearly drawing a bright line on what's in and what's out, and right now there's no line. There's no line. And so when you draw a bright line between what you can and can't do, then people you bifurcate your actions. You're either in or you're out. You're either in compliance with the law or not compliance with the law. So although there are processes where someone could say, we think that this public body has negotiated something that's contrary to this bill, then they have an avenue for that conversation to happen. But there's not that avenue right now.
Do you think it'll keep us competitive with especially superintendents? Because I know it's highly competitive out there for great candidates.
Thank you so much. To Senator Buck from Assemblywoman Benitez Thompson, I believe so. I believe that if someone tells you that you can't land a good person at $350,000 a job with our PERS and our PEB benefit system, I think I would be cautious for anyone who would let that seed grow into a bigger issue of concern for them. You will get good people. I point all the time to our state employees because, in the state of Nevada, we've got kind of a cap on our salaries because we say that our state employees really can't make more than the governor, right? Unless you're contracting out some physician positions and stuff like that. And of course, and she's outside of that as well. But we have the most amazing, dedicated employees who are working for $90,000 to $120,000 a year, who are in with us for 20 or 30 years, doing amazing work with huge, big budgets. You can find great people to do good things without feeling like you have to negotiate away unreasonable bonuses, unreasonable severances. It's, I think, more of a corporate mentality that's contrary to how we think about the use of public dollars, right? So I would say that I have so many examples of great people doing good work that I feel like we've got qualified pools of people out there.
And I'm just always cautious because I know and I've reviewed a lot of the contracts of big districts across the nation, and they're doing the same thing. So I was just wondering if you have examples of other state policies that restrict this more.
Thank you so much for the question, Assemblywoman Teresa Benitez-Thompson to Senator Buck. There are not other state examples. So this was the research done in this state about really some practices that we're seeing regionally that I don't think should take hold in this state. I highly encourage other state legislators to be introspective and to look at what the practice is. And if they see something that is upsetting, then, bring a law to put an end to it. But I think it's worth the merit of a conversation. I think that it's good public policy, and I think that it's where we want to land. This bill does not tie anyone's hands too much, but it is going to address the outliers. It is going to address some trends that ultimately I believe we will regret not taking care of right now.
Thank you, Majority Leader. Thank you, Senator Buck. Any additional questions, members? Well, thank you very much for presenting the bill. We will now go to support. If there's anyone here in the committee room who wishes to speak in support of Assembly Bill 385, and I don't see anyone here in the committee room, so broadcasting, if we can go to the phone lines. Anyone who wishes to speak in support of Assembly Bill 385, we're allotting 2 minutes per caller.
Hello, if you'd like to testify in support of Senate or Assembly Bill 365, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support, please press star 9 now to take your place in the queue. Will the caller with the last 3 digits, 202, please slowly state and spell your name. You have 2 minutes and may begin now.
Thank you, Mr. Chair and members of the committee. My name is Paige Barnes, Paigebarnes. I'm with Crowley and Ferrata Public Affairs, here today representing the Nevada Association of School Boards. The Nevada Association of School Boards represents all school board trustees in the state. We are here in support of AB 385. We believe that this is a fair and reasonable approach to contracting and provides protections to school boards when negotiating contracts. We especially support the provisions that prevent contracts from being paid out in the event a person leaves their position while there is an ongoing investigation. This protects the public, the board, and tax dollars. As Majority Leader Benitez-Thompson stated, the bill has a number of transparency provisions, including preventing the payout if there is an investigation and awarding a bonus during public meetings if metrics are met. The Nevada Association of School Boards appreciates the hard work of the Majority Leader to bring greater transparency and accountability to the process. Thank you for your time.
If you would like to testify in support to Assembly Bill 385, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers wishing to testify in support at this time.
All right, thank you. Now we'll go to opposition. If there's anyone here in the committee room who wishes to speak in opposition, please come forward and please come forward. And we're allotting 2 minutes, and then we'll go to the phone lines. Thank you for being here, sir.
Thank you, Chair Orenshaw, Vice Chair Lang. My name is Wesley Harper. I am the Executive Director of the Nevada League of Cities and Municipalities. The League is respectfully but strongly in opposition to AB 385 as amended. We do appreciate the discussion, the work of the sponsor to bring this bill forward, and the distinguished members of the Senate Committee on Legislative Operations and Elections for hearing it. This bill, while seeking a reasonable outcome, is constructed to create wide-ranging negative consequences. Member municipalities are in a national competition for the country's very best talent. This proposed legislation puts our municipalities at an avoidable competitive disadvantage. The legislation is targeting the rare circumstance. There has been no evidence presented that there is an emerging trend Moreover, and more troubling, creating viable and responsive employment agreements with high-performing officers and employees is the very definition of a matter of local concern. I submit that the manner and method of how to contract with municipal staff primarily affects and impacts areas located within each municipality. On this basis alone, this bill is an overreach by prescribing how a public body secures the talent needed to innovate, deliver, and provide services upon which every Nevadan depends. We hope that the committee assesses this bill with a keen scrutiny and respects the purview of local governments to properly govern according to the direct and unique needs of our residents. Again, thank you very much, Mr. Chair, for your attention and for allowing my statement of opposition.
Thank you very much, Mr. Harper, and thank you for all your presentations you've made throughout the session. It's good to see you in person. I appreciate all you've done on Zoom to educate us about all the work of League of Cities. All right, anyone else in opposition here in the committee room? All right, broadcasting, we can go to the phone lines. We're allotting 2 minutes per caller.
If you would like to testify in opposition to Assembly Bill 385, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 385, please press star 9 now to take your place in the queue. Will the caller with the last 3 digits, 642, please slowly state and spell your name for the record. You have 2 minutes and may begin now. Caller, please press star 6 to unmute your phone. You are unmuted on our end.
Can you hear me now?
We can hear you now. You may begin.
Thank you. Mr. Chairman, members of the committee, for the record, Randy Robison on behalf of the City of Las Vegas. That's RANDY ROBISON. Appearing before you today in opposition to a very specific portion of the bill. That would be Section 1, Subsection A, regarding the fringe benefit portion. We've had the opportunity to talk with the sponsor a couple of different times, a couple of different ways about this issue, and our council feels strongly that this will ultimately limit their flexibility as they are trying to compete for the talent to lead our organization. In discussions with the sponsor of the legislation, we do appreciate the change from the original proposal to the language that's before you today. We think it's better and headed in the right direction. Should the bill proceed, we think it could be narrowed even further to zero in on the very top spot in our organization, as opposed to other tiers. There's no attempt to hide the one by spreading it out to the others in these kinds of issues. The sponsor herself said that 99.9% of public bodies do the right thing, and so we're trying to just target that 1/10 of 1%. But I would also associate Mike with the comments of Mr. Harper from the League in terms of letting this reside with those who've been duly elected at the local level to compete for those who they want to run their organization. And so again, Mr. Chairman, appreciate the time. We're opposed to that specific provision of the bill. The rest of the bill we don't have an issue with. We're not opposed to, but would like to see some either continue to work on Section 1A or perhaps have that stricken from the bill. Thank you, Mr. Chairman.
If you would like to provide testimony in opposition to Assembly Bill 385, please press star 9 to take your place in the queue. Chair, the public line is open and working. However, we do not have any more callers wishing to testify in opposition at this time.
Thank you very much, Broadcasting. Neutral, anyone who wishes to speak neutral to the measure here in the committee room? Okay, I'm not seeing anyone. Broadcasting, is there anyone on the phone lines who wishes to speak neutral on the measure? We're allotting 2 minutes per caller.
If you would like to testify in neutral to Assembly Bill 385, please press star 9 now to take your place in the queue. Again, if you are wishing to provide testimony in neutral to Assembly Bill 385, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, I do not have any callers wishing to testify in neutral at this time.
All right, thank you. Assemblywoman Benitez Thompson, any closing comments you'd like to make? We appreciate you presenting this measure, and thank you.
Chair Orenshaw, I thank you for your time. I thank you for your time and the consideration of this piece of legislation. I think it's the step in the right direction. I think we got to do it now, pull off the Band-Aid and get it done before we get into habits and practices that just make it all the harder to do in the long run. And I respect the cities enormously. I will say this, that we've been very frank. They're great actors. They tend to be, they have no examples that I could find in which they would run afoul of this bill. I know we have a philosophical disagreement on Fringe, that they think it really ought to be open to anything, and because they know they believe their public bodies won't make poor decisions. But I can say, because I'm part of a public body, I see us make all kinds of interesting decisions, and so I am interested in saying that there are some guardrails on Fringe. Thank you for your time consideration.
Thank you very much. Appreciate your passion on this issue. We'll now close the hearing on Assembly Bill 385, and we are going to open the hearing on Assembly Bill 390. We're very lucky to have Assemblyman Frierson, Speaker of the Nevada Assembly, here today. And thank you for presenting Assembly Bill 390. I know today is a very sad day for all my friends in the Assembly. We did recognize our friend Assemblyman Thompson today on the Senate floor and adjourned in his memory. Many of us miss him very much.
Thank you, Mr. Chair, and thank you for those wishes. We certainly carry out the spirit of our colleague in trying to do good work moving forward. I think that's the best we can do. For the record, my name is Jason Frierson, Assemblyman for District 8, Speaker of the Nevada State Assembly, and today I present Assembly Bill 390. I believe that Assembly Bill 390 is a rather straightforward bill that requires that defendants in election contests be notified that such a contest has been filed. Currently, if someone were to contest your election, the contester has no obligation to notify you that such a contest has been filed with the appropriate authority. Typically, in civil cases, for example, the defendant is given every reasonable opportunity to be notified that such a case has been brought against them. This is not uncommon practice in election contests. Per data from the National Conference of State Legislatures, at least 14 other states expressly require that defendants in an election contest are notified. I want to be clear that AB 390 does nothing to change the current process and procedure that exists for challenging an election other than simply notifying the defendant. AB 390 simply ensures that election contests are treated similarly to civil cases and give defendants reasonable time to prepare their affairs and defense. Essentially, there's an expectation that if there's a contest being challenged, that the person who's being challenged would be notified. But if you ask the Secretary of State's office, they assume that the person contesting the election notifies the subject, and the contester is assuming that the Secretary of State is notifying the person, and often is the case, no one simply notifies the contester. So this is, or the person being contested. So this is an effort to just shore that up, to make sure that if you're going to contest an election, tell the person whose election is being challenged. Mr. Chair, with your permission, I'll walk through the provisions of the bill. Section 1 addresses the process for a candidate at any election or any registered voter to contest the election of a candidate except for the office of U.S. Senator, Representative in Congress, office of the Governor, Lieutenant Governor, Assembly Member, State Senator, Justice of the Supreme Court, or Judge of the Court of Appeals. Under existing law, to contest an election, a written statement of contest must be filed with the district court. AB 390 simply adds to Section 1, Subsection 5, that a contestant must notify the defendant that a statement of contest has been filed. Section 2 addresses the process for a candidate or registered voter to contest the election for the office of State Assembly and State Senate. A statement of the contest must be filed with the Secretary of State under existing law. AB 390 adds language to Section 2, Subsection 1 to add that the contestant and the Secretary of State shall notify the defendant that a statement of contest has been filed. Section 3 addresses the process for a candidate or registered voter to contest the election of the office of Governor, Lieutenant Governor, Justice of the Supreme Court, or Judge of the Court of Appeals. Similarly, Under existing law, a statement of contest must be filed with the Secretary of State, and AB 390 adds language that a contestant and the Secretary of State shall notify the defendant that a statement of contest has been filed. In conclusion, AB 390 is simply an effort to give anyone whose election is contested the benefit of being notified at the very least. This concludes my remarks, and I am happy to answer any questions that the committee may have.
Thank you very much, Speaker Frierson. Any questions for Speaker Frierson? Senator Severs-Gansert.
Thank you, Chair Ornschall. So I think it makes sense to give notice to the person, to the defendant, but how do you envision seeing that? Do you think there's going to be regulations, or the different entities will determine what that looks like? It's broad language.
Thank you. For the record, Jason Frierson, again, it is broad language, and it is not intended to create unreasonable or new burdens other than notifying the party. And so whether it's, I think it would be subjectively up to the court and the Secretary of State as to whether or not a person was notified, but this simply adds the factor that they must be notified. So it wouldn't preclude, for example, the Secretary of State coming up with specific measures that would satisfy that, whether it's personal service or certified letter. It just requires that there be an effort to notify the person that their contest is being challenged.
Okay, thank you.
Thank you. Any follow-up, Senator Severs-Gansert?
So, I guess so. Again, the language is broad, and so there's no timeline on it either, like a certain period within a certain period, because you could basically contest it and not tell them for 3 months. I mean, I mean, it would probably get resolved by then, but also just how you notify, when you notify, and then the contestant notifying versus, say, a court or a middle person. So in Section 2, you've got the Secretary of State. You've got an and, actually, the contestant and the Secretary of State, and I wasn't really sure why both, but, following up on time frame and as well.
Thank you. Again, Jason Frierson, for the record. I think it is broad by design. This isn't a civil lawsuit. This isn't a criminal complaint. I think that we cover the lack of specificity with respect to how you notify by requiring that both the Secretary of State and the person contesting it provide that notice. And it's to the extent that it impacts timeline. For example, with the state legislature, we govern ourselves and we govern that process, and we can come up with those timelines, but we can also give additional time for someone who says, well, this occurred 2 months ago, but I just got notified of it. And then I think that either the court or the Secretary of State, or in the case of the legislature, would be able to take that into consideration in setting up a timeline for responses.
Thank you. And I do see we have Chief Deputy Secretary of State Mark Voloshin on the Zoom. I appreciate you being there, Chief Deputy Secretary of State. Maybe following up on Senator Severs-Gansert's question, if this bill passes into law, could the Secretary's office promulgate regulations as to what kind of notice would be, time frames for notice, whether it be regular mail, registered mail, certified mail?
Thank you, Chair Ornschall, for the question. Mark Voloshin, Deputy Secretary of State for Elections, for the record. Absolutely. We certainly would make sure that any regulations that pertain to this change, if the bill is passed, would cover the timeline specifically to make sure that the contestant as well as the agency are all very clear in understanding what that looks like. As the speaker mentioned, it would back up really from the start of the legislative session, which is the big requirement between the certification and the legislative session. So if somebody contests the election in accordance with the statutes, we would simply make sure that those regulations are specific enough to allow an appropriately timed notification.
Thank you very much, Chief Deputy Voloshin. Members, any additional questions? Senator Buck.
Thank you, Chair Ornschall. I'm just wondering why an amendment wasn't defining what qualifies, certified mail, cheapest mail method, or maybe address how it's listed on your C&Es.
Thank you. For the record, Jason Frierson. Again, to you, Senator Buck, it was broad by design. I think the election contests are different than other forms of litigation or challenges, and not everybody's savvy. Not everybody's an attorney. And I don't think that the provisions of this bill are proposing that they have to hire an attorney to be able to comply. And so I think that we're seeking to find a balance that allows an average citizen or an average candidate to be able to successfully at least start the process without unduly burdening them with having to hire an attorney and other things. This is simply saying, if you're going to challenge an election, tell them.
Thank you very much, Speaker. Any additional questions, Senator Buck? Any members? Senator Seavers-Ganser?
Thank you, Chair Orchard. So I appreciate you bringing this forward because I think that is fair. And I do appreciate the Secretary of State's office weighing in on this. And I also think that you have to have access and that you don't want to have to engage an attorney because it does preclude people from moving forward as well. So thank you.
Thank you very much. Thank you, Speaker, for joining us. And I know you've got a very tight time frame, so if you have to leave, we completely understand. Anyone else who wishes to speak in support of Assembly Bill 390 here in the committee room, please come forward. All right, not seeing anyone in the committee room broadcasting. Is there anyone on the phone lines who wishes to speak in support of Assembly Bill 390?
If you would like to testify in support to Assembly Bill 390, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support to Assembly Bill 390, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, we do not have any callers at this time wishing to testify in support.
Okay, thank you. Then anyone on Zoom who wishes to speak in support? Okay. And we now will go to opposition. Anyone in the committee room who wishes to speak in opposition? Broadcasting will go to the phone lines. Anyone who wishes to speak in opposition to the measure, 2 minutes per caller.
If you would like to testify in opposition to Assembly Bill 390, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 390, please press star 9 to take your place in the queue. Chair, the public line is open and working. However, we do not have any callers wishing to testify in opposition at this time.
Thank you, broadcasting. Neutral. Anyone who wishes to speak neutral to the measure, either here in the committee room, on Zoom, or on the phone lines. Broadcasting, if we can go to the phone lines, we're allotting 2 minutes per caller.
If you would like to testify in neutral to Assembly Bill 390, please press star 9 now to take your place in the queue. Again, if you'd like to testify in neutral to Assembly Bill 390, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, we do not have any callers at this time wishing to testify in neutral.
Thank you very much. Speaker, any closing comment? No, thank you. We appreciate you presenting Assembly Bill 390, and I think notice is essential for someone to have their due process rights. Thank you very much. We'll close the hearing on Assembly Bill 390, and Minority Leader Titus has been patiently waiting. I think you got here before I did, so I would like to open the hearing on AJR 1, and thank you for your patience, Assemblyman Brown-May.
Well, thank you, Senator. I appreciate the opportunity and members of the Senate Committee on Leg Ops today to hear AJR 1. For the record, I'm Assemblywoman Dr. Robin Titus, representing Assembly District 38, which encompasses Churchill County and most of Lyon County. I am introducing Assembly Joint Resolution 1, which proposes to amend the Nevada Constitution. This resolution is straightforward. It changes 4 words in the Nevada Constitution. Some may wonder, why do we need to change the Constitution to address 4 words? Well, let me tell you what those 4 words are: insane, blind, deaf, and dumb. These words are found in Section 1, Article 13 of our Constitution. This section requires the state to care for certain populations with disabilities or who suffer from mental illness. The whole section reads like this. Section 1, institutions for insane, blind, deaf, and dumb to be fostered and supported by state. Institutions benefit of the insane, blind, deaf, and dumb, and such other benevolent institutions as the good, public good may require, shall be fostered and supported by the state and subject to such regulations and as may be prescribed by law. I am aware that when the Nevada Constitution was written, different terminologies were used to describe persons with disabilities or mental illness. However, more than 156 years after Nevada was admitted to the Union, it is time to give these words a critical look. We should change them to contemporary language that is not deemed to be discriminatory or narrow. I propose we revise this terminology in the following manner: from the insane to persons with a significant mental illness, from the blind to persons who are blind or visually impaired, and from the deaf and dumb to persons who are deaf or hard of hearing. The idea to change this language in our Constitution came from one of my constituents, Mr. Andrew Campbell, who unfortunately was not able to join me today. He works in Churchill County in middle school as a special education teacher. Most of his students have severe, profound disabilities. Mr. Campbell also teaches American Sign Language in an after-school program and is very much aware of the needs of persons who are deaf or hard of hearing. He describes them as smart and dedicated people in our society who work in banks, teachers, or engineers. His own grandfather belonged to this population as one of Boeing's first 100 employees that designed an aircraft. I'm grateful to Mr. Campbell who brought this to my attention. Let me explain a little bit more detail about the amendments I propose. First, I wanted the new terms to start with persons. We must stop categorizing people who suffer from an illness or disability by putting an emphasis on their illness or their disability, such as the blind or the deaf. Instead, these are all individuals that happen to have an illness or a disability. But first and foremost, they are persons. Second, calling persons who have a hearing loss dumb or in our Constitution is plainly offensive. This term must go. Additionally, many people in our society are not completely deaf, but may suffer from different degrees of hearing loss. The definition in the Constitution is too narrow, and therefore I think it should be persons who are deaf or hard of hearing. Insane is another one of those derogatory terms that I recommend replacing. We know the words matter, and when you stigmatize individuals with such a term, it may lead to a negative result in the long run. Research shows that stigmatizing persons with significant mental illness may create barriers for them. They may face discrimination and prejudice when renting homes, applying for jobs, accessing mental health services. Stigmatized people are also less likely to seek the help that they need to treat their condition, which may make their condition worse. Using the term insane in our Constitution for people who suffer from mental illness helps to perpetuate the stigma. Therefore, it should be replaced with a more dignified term persons with a significant mental illness. Blind is not necessarily a discriminatory term, but I think it's too narrow. If a person is blind, he or she may suffer a complete or nearly complete vision loss. However, this does not include any of the people who have visual impairment that causes them difficulty with normal daily activities, and which cannot be fixed by simple wearing lenses or contact lenses. Persons with visual impairments may not be able to walk or read without adaptive training or use the assistive technology. Contemporary training and assistive technology are for all people who have some kind of visual impairment. Therefore, this language should be updated as well, and I propose the term persons who are blind or visually impaired. In closing, I believe we must do a better job in making sure that we do not discriminate and stigmatize persons with disabilities or mental illness. A first step is to ensure no discriminatory, stigmatizing, or derogatory language is in our Nevada Constitution, and AJR 1 will provide for that. At this point, I will just go over the bill. Sometimes these simple bills are the hard ones, and they're short ones, but this truly is a one-pager. 2 pages if you flip it over. It's on the second side that we get to the meat of the issue, and in it says it's what I had quoted earlier. So with that, I'm happy to close and open to any questions.
Thank you very much, Minority Leader Titus. Thanks for presenting the bill. Vice Chair Lang.
Thank you, Minority Leader. Thank you for being here today. And I think you hit the nail on the head when you said words matter. And when I read this bill, I couldn't believe it. And so I really thank you for, we've heard so many bills about discrimination in this session, and I really thank you for taking the time to find this and to fix it, because words do matter, and we need to value each person in our community.
Thank you for that. And if I might also reply, I've had folks reach out to me and say, well, we've taken out that language, and we have in many instances in NRS. There's been bills in the past that fix some of this language, but we haven't gotten to our Constitution, and that requires a little bit of different process.
Thank you, Assemblywoman Titus. Thank you, Vice Chair Lang. Senator Severs-Gansert.
Thank you, Chair Orenshaw, and thank you for bringing this forward. I think when we read this, everybody was appalled, thinking, we can't imagine this is in the Constitution. I just had a question about persons with significant mental illness. It seems like we're starting to go towards behavioral and emotional health issues versus mental illness. Just a thought, and I don't know if there's a substitute for that or not, because we've used we used to always use mental health, but we don't seem to use that anymore.
Thank you, Senator Gansert. The terminology that I had, we worked through multiple layers and multiple folks in the interim because this was a pre-filed bill that I had. So I actually landed on the language that was submitted to us by the Aging Disability Service Division. So that was a language they felt was probably the one that would be the most appropriate to get through a couple sessions, which is what this would have to do without changing it. And so that's the language that the director, Jennifer Richards, had come up with, and we kind of all landed on. And again, it's a moving target, right? As we in society have changed our terminology, I reached out for somebody that would give me some more stability on that.
Thank you. I agree it's somewhat of a moving target. And then you did add the persons with intellectual or developmental disabilities, which makes sense too, so thank you.
Thank you, Minority Leader Titus. Thank you, Senator Severs-Gansert. Members, any additional questions? Well, thank you very much for bringing this bill, Minority Leader, and really appreciate it. Is there anyone else in support of AJR 1 here in the committee room? Please come forward, state your name, and thank you for your patience.
Remember to turn my mic on this time. Good afternoon, and thank you, Chair Orenshaw and committee members. For the record, Liz Davenport, L-I-Z-D-A-V-E-N-P-O-R-T, the Boyd Law intern here on behalf of the ACLU of Nevada in very strong support of AJR 1. Removing outdated, derogatory, and offensive language from our state's constitution just makes sound policy. Legal terms must be updated. Just as Minority Leader Dr. Titus explained, much too often these terms are institutionalized, continuing to allow them to be used and persist in our society and continuing negative, incorrect social stigmas. The American Psychology Association's Committee on Disability Issues has emphasized the need to avoid offensive expressions and recommends policy that places people, not their disability, first, just as Minority Woman Dr. Titus explained. U.S. Congress has also recognized this 10 years ago, and in 2010 and 2012 removed similar derogatory terms such as lunatic from the U.S. Constitution. Nevada should follow in their footsteps and urges your support as well on AJR 1. Thank you.
Thank you very much. Thank you for your testimony. Anyone else in support of AJR 1 here in the committee room? On Zoom? Broadcasting, if we have anyone on Zoom or anyone on the phone lines who wishes to speak in support of the measure, we're allotting 2 minutes per caller.
If you would like to testify in support to Assembly Joint Resolution 1, please press star 9 now to take your place in the queue. Again, if you would like to testify in support to AJR 1, please press star 9 now to take your place in the queue. Will the caller with the last 3 digits, 779, please slowly state and spell your name for the record? You have 2 minutes and may begin now.
Yes, my name is Ace Patrick, ACEPATRICK. Thank you, Chairman Orenshaw, and members of the committee. My name is Ace Patrick, and I am the chair of the Nevada Statewide Independent Living Council and a person with multiple disabilities living in Sparks, Nevada. As you may already be aware, I have recently provided my personal story to assist in changing disability language that is outdated. It is important to remember that person-first language needs to replace some offensive terminology that has no business in the Nevada Constitution. Words do matter. My life changed dramatically when people started seeing me as a person first, who happens to have disabilities, and it has made an enormous impact on the quality of my life. Changing our language to be respectful helps eliminate the negative stigmas that have been imposed on people with disabilities. I want to thank the committee for bringing it forward.
Will the caller with the last three digits, 611, please slowly state and spell your name for the record? You have 2 minutes and may begin now.
Good afternoon, Chairman Orenshaw and members of the committee. This is John Piro, Johnpiro, representing the Clark County Public Defender's Office. As lawyers, we understand all too well that words have power and language is important. And the language that Assemblywoman Titus is seeking to change in this bill is both stigmatizing and detrimental to people in our state. We thank her for bringing it forward, for bringing this bill forward and seeking to remove this language from the guiding document of our state. And we strongly urge support of this bill. Thank you.
Will the caller with the last three digits, 584, please slowly state and spell your name for the record? You will have 2 minutes and may begin now.
Good afternoon, Chairman Orenshaw and members of the committee. My name is Jennifer Richards, Jennifer Richards. I hold the office of the Attorney for the Rights of Older Persons and Persons with Physical Disabilities, an intellectual disability, or a related condition under NRS 427A, and serve at the pleasure of the Governor. I've submitted written testimony, but I would like to echo the comments of the other callers and reiterate how critical this step is for the disability rights movement to ensure that there is a paradigm shift from viewing persons with disabilities as objects of charity, medical treatment, or social protection to full and equal members of society with fundamental rights that deserve respect and acceptance as part of the diverse, as part of human diversity. We must respect these individuals as part of our community and not use pejorative or offensive language. Again, I submitted written testimony, so I won't take up any more of your time, but we urge your support of AJR 1, and we thank Assemblywoman Titus for collaborating on this measure and bringing it forward.
If you have recently joined the meeting and would like to testify in support to Assembly Joint Resolution 1, please press star 9 now to take your place in the queue. Will the caller with the last three digits, 656, please slowly state and spell your name? You will have 2 minutes and may begin now.
Hi, good afternoon, Chair of the Senate Legislative Operations and Elections. My name is Dora, Martinez, and I'm Nevada Disability.
I apologize, Ms. Martinez, but I think we had a very bad connection there. If you can hear me and are able to call back in, we'd certainly like you to be able to make your comments in support of the measure, but we had difficulty hearing you. So broadcasting, if you see that number come back, or if it's possible to call Ms. Martinez back, I just hate for her not to be able to make her her comment in support.
Chair, she has recently come back. If you could please begin your testimony.
Hello? This is Dora Martinez. Are you all able to hear me?
Yes, we can hear you much better now. Thank you.
Oh, thank you. I apologize. Thank you so much. So Dora Martinez, for the record, I want to ditto the prior callers. We are people with disabilities, and it's true what Ms. Ace Patrick said, but when people view you as a person first, and then they are aware of your abilities, it really does make a difference. Thank you very much. Have a great afternoon. May the force be with you.
And broadcasting, I believe Mr. Beardsley is on Zoom and wishes to make comment in favor of the measure.
Yes, that's correct. Hello. Chair and committee, my name is Jeff Beardsley, Jeffbeardsley, for the record. I want to support what the others have said prior to me. We need to clean up this language and have needed to do this for years. From my experience, when people label me as hearing impaired, I find that ironic. I always challenge them by saying, you're deaf impaired. Do you sign? And they don't. So it's a way for me to educate them about language. In our community, we do consider ourselves be deaf, hard of hearing, and deaf blind. That's what matches our identities in our community. But we also support Dr. Titus's comments, and I appreciate others' comments, and thank you for allowing me to testify.
Thank you very much, Mr. Beardsley. Broadcasting, is there anyone else on the phone lines or on Zoom who wishes to make comments in support of Assembly Joint Resolution 1?
If you've recently joined the call and you would like to testify in support of AJR 1, please press star 9 now to raise your hand to join the queue. Chair, there are no additional callers at this time.
Thank you, Broadcasting. We'll now go to opposition. I don't see anyone in the committee room who is here for opposition. Anyone on Zoom or on the phone lines, Broadcasting, who wishes to speak in opposition to Assembly Joint Resolution 1? We're allotting 2 minutes per caller.
Thank you, Chair. To testify in opposition to AJR 1, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, Broadcasting. I don't see anyone else in the committee room who would be here for neutral, but if there's someone who wishes to speak neutral to the measure, either on Zoom or on the phone lines, we're allotting 2 minutes per speaker.
To testify neutral on AJR 1, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you very much. Minority Leader Titus, any closing comments you'd like to make?
Thank you, Mr. Chair and committee, and I just want to acknowledge the folks who have called in and voiced their support and the folks who've brought this to my attention. Again, this is just a first step. There's many issues in our NRS itself that needs to be cleaned up. If you just throw in the definition insane or the word insane in our Constitution or NRS, you'll have 67 hits in that. So hopefully we can clear up some of that. But I think we have to start at the core and the foundation of everything else we do in the state, and that's our Constitution. So hopefully we'll get this back next session, and we'll get this passed forward here and move forward with it. And thank you all for your time and good observations. Thank you.
I appreciate the measure, and thank you to your educator in your district who brought this up to you, because honestly, I did not, it's been a while since I'd looked at that section, and I was wasn't.
Yeah, thank you, because I felt embarrassed also, if I might, Mr. Chair, when we've all been here for a little while, and to have this constituent reach out and say, hey, did you know this is still in there? And I went, oh my goodness. Anyway, thank you.
Thank you very much, Minority Leader. We'll now close the hearing on Assembly Joint Resolution 1, and Assemblywoman Brown May, thank you for your patience. We'll now open the hearing on Assembly Bill 421.
Thank you. I appreciate the opportunity to be here. Thank you, Chair, Vice Chair, members of the committee. As the freshman Assembly appointee, it is always my honor to wait my turn, so I sincerely appreciate having the opportunity to present to you today.
Well, thank you for being here.
So for those of you who don't know me, I am personally thrilled to be here and to bring this measure forward to you, having spent the last 20 years of my career before becoming a legislator as a disability support advocate. This measure in particular should again be very simple, and I'm thrilled to have the opportunity to follow the minority leader as the issue is pretty much exactly the same. As we begin, I would like to very much give credit where credit is due, because I think it's the members of the disability community that have brought these issues to our attention, and the good works of the Nevada Center for Independent Living, and how those coalitions come together to bring together diverse members of our community to really consider how do we lift people who are diagnosed with disabilities or different abilities than many others. So first, I am Assemblywoman Tracy Brown May, and I am proud to represent Assembly District 42. With me is Mr. Beardsley, who you will see is a member of the Nevada Deaf Commission, and he will present a little bit later as soon as I finish bill comments. A letter of support is also uploaded to Nellis that you will find from the Nevada Governor's Council on Developmental Disabilities with regard to this language, as well as the National Alliance on Mental Illness, or Nevada NAMI. So today we're here to present Assembly Bill 421 for your consideration, and as you so aptly said, Senator Lang, words do matter, and how we refer to each other matters. So the words and labels that we use in our statute have a profound effect on how we address each other. So refusing to use those terms is why we're here today. For the people who are diagnosed with mental illness, replacing those offensive terms in our statutes is the first step to reducing the stigma associated with any mental health condition, removing discriminatory terminology, and hopefully beginning to shift the focus toward treatment and recovery. The same is true for our Nevadans who are deaf or hard of hearing. You heard Mr. Beardsley say just a short time ago that he would counter he does not have a disability, but that we, as hearing, may be the ones who are disabled. So many of the terms that we use refer to members of our community are offensive, they're inaccurate, and they are clearly outdated. The negative terminology, as you heard, continues to persist in our law and in popular culture, and including the label deaf and dumb is wholly inaccurate. The National Association for the Deaf calls this a relic from medieval England. The organization also notes that the Greek philosopher Aristotle used the label deaf and dumb because he thought that deaf people were incapable of learning. Well, that is not the truth. So maybe it's time that we fix it in our language. So we know that. Most recently, even terms hearing impaired and hearing disabled are offensive. As Mr. Beardsley stated earlier, perhaps we are the ones disabled. These terms focus on what people cannot do by establishing a social norm and addresses impairment. I would also counter that people do not suffer with a disability. Many people are born to be differently abled, but do not suffer with that diagnosis. I'd like to run through the sections of the bill, if it please the chair. Section 1 contains two key provisions. Subsection 3 of Section 1 makes specific reference to what's considered the preferred and respectful language in the Nevada Revised Statutes for people with mental illness and lists words and terms that are not preferred. We did not address the term insane intentionally because it can be used in civil or in criminal litigation as a diagnostic until and unless we can get our arms around what is that entire scope in the Nevada Revised Statutes. We simply went with this. Subsection 4 requires that respectful language and sentence structure be used for all of our NRS references relating to people who are deaf or hard of hearing, and additionally it specifies the terms that are not preferred should be avoided. We have done this at other previous times in our history by removing the R word from many of our statutes. In similar manner, Section 2 of Assembly Bill 421 specifies that our state regulations codified in the Nevada Administrative Code must also use respectful language and sentence structure when referring to people with mental illness or people who are deaf or hard of hearing. Finally, Section 3 specifies the Legislative Council will update the wording changes and reprints and supplements of both the NRS and the NAC to conform to the provisions of this bill. And then, Chair, if you please, Mr. Jeffrey Beardsley can provide additional remarks relative to this bill.
Thank you very much, Assemblywoman. Thank you for presenting this important bill. Mr. Beardsley, please go ahead. Thank you for being here.
As she just mentioned, I agree. We have lived with years of stigma throughout history. I've experienced oppression by society based on how they view deaf people as being mentally limited and limited in our ability to function. But the way that they use language really reflects on their understanding of what disability means. We in the disability community know that they have some disabilities. We can do anything, in my case, except hear. We know that there are deaf people working in state agencies, there are deaf policemen, deaf firefighters, and others working in other types of employment. Deaf people are an important part of our world. We can build a bridge to support each other. So again, hearing impaired is an offensive term for our community that's been used for years. And when I challenge people with that by saying you must be deaf impaired, and I make the point, even though they try to say what I cannot do, I challenge them by saying that they cannot sign. So we have to educate each other so that we can move forward and have smooth communication and work through this. Now, these days we have the technology available to improve communication access so that the deaf community and the hearing community can have equal access. And I have seen some improvement in that arena. However, the terminology must be changed so that the language will always be respectful to the community of people with disabilities, people who are deaf or hard of hearing, deaf blind, people who are blind and visually impaired. All of that language needs to be respected. Thank you for the time to provide my comments.
Thank you very much, Mr. Beardsley. Any additional presenters, Assemblywoman, or should I go to questions now?
Thank you. That does conclude our presentation at this time. We're happy to take questions.
Thank you very much for presenting the bill. Members, any questions for Assemblywoman Brown-May? Senator Severs-Ganser.
Thank you. I just want to thank you for bringing forward the legislation and welcome you to the Senate.
Vice Chair Lang.
I think that I also want to say the same thing I said to the minority leader. Words do matter, and this is important, and thank you for bringing it forward.
Thank you. Yes, I agree with everything that was said. Thank you for bringing forward this legislation. And I guess my question, I think, just one question. I noticed here on page 2, it says words and terms under 3A, words and terms that are preferred for use in Nevada revised statutes include without limitation persons with mental illness. And I noticed on the proposed amendment to the Constitution, they had the language persons with significant mental illness. And I don't know if that, well, I'm not sure if that would create any difference, or maybe that's something we'll look to, maybe next session we'll see if the AJR 1 passes, and we'll have it as a proposed constitutional amendment, because the NRSs are easier to amend at the next session.
Thank you, Chair. Tracy Brown-May for the record. This bill provision was really about the 2 sections that govern folks with disabilities currently in our NRS. So NRS 435, and then there's another chapter that governs residential support providers. We really looked closely at the language that was existing in those areas, but wanted to make sure that it was encompassing through all of our NRS, so that as we made those revisions, we would go back. So that's why those 2 paragraphs are amended to be that language as a preferred. Whether or not there would be a severity attached to the mental illness, I am with you, would look forward to walking that through with regard to that constitutional amendment, because I think that's very different. The other piece that's in the constitutional amendment that you won't find here is the word institution, which I think was originally what was written into the constitutional amendment. I can tell you that the community of people who have intellectual and developmental disabilities would prefer never to be associated with an institution of any kind. And so I think that's just one of the pieces. I also look forward to seeing where that AJR 1 goes. Those are very good and positive changes, but not substantive to these chapters.
Thank you very much, Assemblywoman. And I do want to note that there are letters of support that should have been uploaded on Nellis from the National Alliance on Mental Illness, Robin Reedy, and from Carrie Horn, Executive Director of the Nevada Governor's Council on Developmental Disabilities. And so members, you can find those letters on Nellis. And also from, I believe, those are the two for that measure. Any additional questions? No. Senator Sievers-Gansert.
Thank you, Chair Orenshaw. So kind of following up on what you just said, when you do look at the constitutional language, it does say institutions, and it's talking about for the benefit of persons with the severe, or I think it says significant mental illness, and I think that is probably differentiated because it's related to institutions and that where the state is doing something on their behalf. But that said, I'm wondering, since we have you here and you've been a disability advocate, instead of institutions, do we have entities, or what type of language? Are the bill sponsors gone? But I wanted to dive a little deeper on a substitute for the word institutions that may be acceptable to persons with disabilities.
Thank you, Senator. Tracy Brown May for the record. So following up on that piece, and I appreciate that line of questioning, the word institution was not in the original AJR that we looked at in the Assembly. It came by amendment later and then went to vote. So it is, however, in the original constitutional language, right? So the pieces that they're working to change are just the way that we're referring to people who have a diagnosis and not to eliminate the word institution. Now, that said, people with intellectual and developmental disabilities, I do not believe were included in the original language that the minority leader presented. They were added in later. That was where that word institution sort of popped up as, wow, maybe we want to pay attention to that currently. I would say that the state is working and has worked for a number of years to eliminate institutions in that way. So a go-to word would be a facility or an entity, or, right, because you're working to support the interests of people with disabilities. I don't know that you have to refer to any brick and mortar institution of any type in order to get across the intent of the language in the Constitution.
Thank you for that response. In my mind, I was thinking about the word entity because I agree with you. It's not necessarily tangible bricks and mortar. It's organizations, it's people, it's infrastructure. So thank you. And maybe we can talk to the minority leader. It would be a second check. Yeah, but I'm just thinking if we're going to go through the process of changing the Constitution, we want to get it as close as we can to good, recognizing again it's somewhat a moving target. Thank you.
I appreciate your comments, Senator Sievers-Gansert, and I was thinking maybe either entities or facilities or inpatient treatment facilities rather than institutions, because you're right, institution, even just that term kind of makes me shudder to think about it. I certainly don't hear it used very often.
Right.
Vice Chair Lang.
No, I was just going to add on to that. So I had just mentioned to Chair Orenshaw a few minutes ago that words matter on when you go to a constitutional amendment. And you know how it is, people pick apart every little piece. So we have to be really careful that we are looking out to the organizations and to the communities and making sure that we have the right words when it goes for a constitutional amendment so that it has the best chance of passing.
Thank you, Vice Chair Lang. I appreciate that. Any additional comments or questions? Senator Sievers-Gansert.
Yeah, thank you, Chair Orenshaw. Again, I think because the world has changed so much that we need to find a word if we do offer an amendment to this that encompasses organizations, not just bricks and mortars. And I'm kind of thinking facilities still leads you to institutions. So we can think about it some more. We have a little bit of time, but I appreciate the conversation.
Maybe treatment facilities or treatment?
Well, I don't know because
maybe.
that goes back to like institutionalizing somebody or putting them in a facility to stay versus entities that may help them as outpatients. And because right now, too, if you think about how the state's trending, we tend to take care of people, provide support services in-home or in-home facilities, kind of in-home facilities, right? So
And there's a lot of, I know that now there are a lot of, oh gosh, I'm forgetting the term of art, outpatient, but where someone goes kind of 8 to 5 to what would be an inpatient facility, has all the treatment, but goes home and sleeps at night with their
Right.
family. and
Daycare, day centers.
Intensive
and things like-
outpatient therapy is something I've heard.
Right.
I believe Mr. Beardsley, broadcasting, Mr. Beardsley, can we go to Mr. Beardsley?
Yes, Chair.
Thank you, Chair. Yes, I have another comment to make. I want to make sure that I emphasize that deaf people and hard of hearing people are raised differently. I do not speak in the same way that hard of hearing people may have been trained to. And they may have some benefit of their hearing. And I know that some hard of hearing people have cochlear implants so that they can speak and hear some. Some do sign as well, although not all of them. However, we work collaboratively in our community as a group, both deaf and hard of hearing people. So because society sees us as a collective, even though we have different experiences growing up. I just wanted to clarify that, and thank you.
Thank you very much, Mr. Beardsley. Thank you for your comments. Okay, any additional questions? Not seeing any. Thank you for presenting the bill, Assemblywoman. We'll now go to support for Assembly Bill 421. Anyone? I don't see anyone here in the committee room, so we'll go to broadcasting. We can go to Zoom and the phone lines. If there's anyone who wishes to speak in support of Assembly Bill 421, we're allotting 2 minutes per speaker.
If you would like to testify in support to Assembly Bill 421, please press star 9 now to take your place in the queue. Again, if you would like to testify in support to Assembly Bill 421, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers wishing to testify in support at this time.
Thank you very much, broadcasting. I don't see anyone in the committee room for opposition. Is there anyone either on Zoom or on the phone lines who wishes to speak in opposition to the measure? We're allotting 2 minutes per caller.
If you would like to testify in opposition to Assembly Bill 421, please press star 9 now to take your place in the queue. If you would like to testify in opposition to Assembly Bill 421, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers wishing to testify in opposition at this time.
Thank you very much. We'll now go to neutral. There's no one here in the committee room in Carson City. So if we can go to the Zoom and the phone lines, broadcasting anyone who wishes to speak neutral to the measure. 2 minutes per caller.
If you'd like to testify in neutral to Assembly Bill 421, please press star 9 now to take your place in the queue. Again, if you'd like to testify in neutral on Assembly Bill 421, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, we do not have any callers wishing to testify in neutral at this time.
Thank you very much. Any closing comments, Assemblywoman? All right, thank you very much for presenting the bill. And comments, Senator Severs-Cancer?
Thank you, Chair Earnshaw. I was able to reach out to the minority leader, and she is open to that change. She thinks that's a good idea and wants to make sure we get the language right. And I kind of suggested entities, so just as we move forward. Thank you.
Oh, great, thank you. Appreciate that. Thank you for everybody's input on that. Well, we'll close the hearing on Assembly Bill 421. Thank you, Assemblywoman, for presenting. And our last item is public comment. I don't see anyone in the committee room, so broadcasting, if we can go to the phone lines and see if there's anyone who wishes to make public comment. We're allotting 2 minutes per caller.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, we do not have any other callers wishing to provide public comment at this time.
Well, thank you very much, broadcasting, and want to thank all the members and the staff. Thank you for all the good questions, and we're adjourned.